Drug crimes. What can you do? Is there a way to defend if you or a loved one has been charged with a drug crime in Texas? Hi, I'm Jeff Hampton with the Fulgham Law Firm. Today I want to give you a drug crime guide. I want to give you as much as I can in the time frame that I have, a little bit of an A to Z approach of some things that you might need to know if you or a loved one has been charged with a drug crime in Texas. If you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Drug Crime in Texas. All right, let's jump right into this. Now listen, it's no secret that the state of Texas has a history of treating drug crimes very harshly. In fact, there are still laws on the book in the state of Texas that treat all types of things from marijuana, THC oil, and other things as criminal actions that a good portion of the remainder of our country does not treat that way. But you know, the law is currently what it is. So the reality of it is when we look at this situation, it's important that we understand what Texas law says about drug crimes and what it is that you can do about it. Now, because Texas has a very strong drug crime tradition, we start looking at cases and we want to break them down. Certain crimes have been designated as misdemeanor offenses, misdemeanor drug crimes. Other cases have been designated as felony. So for example, possession of drug paraphernalia, that's a Class C misdemeanor ticket. That's a citation. And it's punishable only by a fine of up to $500. But then if you are literally selling, so if you have possessing methamphetamine, cocaine, heroin, more hardcore drugs, if you start either possessing or delivering, selling in some way some of these items, you could be facing all the way up to a first-degree felony in Texas. So the first thing we need to do is break down a few things. What is possession? When people talk about drug possession, what does that mean? Texas law defines possession as the actual care, custody, or control of a drug. And that drug must be an illegal drug. So the general nature of this definition allows for charges against you even if you don't own the drugs. So a lot of common misconception is that people say, well, they're not my drugs. I don't own them, so I shouldn't be charged. No. They do not have to prove ownership. The state of Texas only has to prove that you intentionally or knowingly exercised care, custody, or control over the drugs, okay? And so one of the things that people look at on that is the prosecutor will many times look to see, was it within your wingspan? Was it on your person? Was it in a place where it looked like there was some, where you would have had access or had knowledge of where it was? Or did you exercise control of it? Was it in your car? Was it in your purse? Was it in your wallet? Those are the kind of things that they're looking for specifically to prove the element of possession. But remember, a prosecutor must prove that element of possession beyond a reasonable doubt. And one of those things that we find sometimes is, what if you did not know? You might have actually been exercising control or care over it. Maybe it was under your seat and you were a passenger in a car, but you didn't know it was there. Well, if the prosecutor cannot prove that you intentionally or knowingly possess those drugs, then they don't have a case. So these elements must be broken down very specifically and analyzed by your criminal defense attorney to make sure you have the strongest case possible if you've been charged with a drug crime. Now, Texas law also considers, let's talk about distribution and delivery. When you look at delivery, it's basically they're the same thing. Distribution and delivery are the same thing. Distributing means delivering a controlled substance, where delivering means transferring a drug to someone else, including selling the drug. So, that can be actual delivery. It can be actual a hand-to-hand situation, or constructive delivery. Actual delivery is when you physically hand it over to one person from another person. Constructive delivery is when there's no physical handoff between you and that other person, but you are still in control of the drug and you are facilitating that delivery aspect of it, okay? So those are those two things. Now, so we've talked about delivery, we've talked about possession. What about possession with intent to deliver, or possession with intent to manufacture? One of the most common drug charges is for police officers to look to charge you with possession with intent to deliver. Now, what does that mean? Well, look, manufacturing is one thing. Manufacturing is a little bit harder for the prosecutor to prove, because there they have to show that you intended to produce, prepare, compound, convert, or process a controlled substance other than marijuana. So, but it's a little different when you start talking about actual intent to deliver. When you start talking about deliver, that's a different situation. They're looking for surrounding circumstances. What would some of those surrounding circumstances be? So possession with intent to deliver, they're looking for baggies. Maybe they're looking for a scale. Maybe they're looking for large amounts of the substance. So if you have what they believe to be more than a usable quantity of that, in other words, it's not for just a user, but they believe the amount that you have, you would only have it because it's made to sell and distribute to others, they can try to charge you with possession with intent to deliver. Now, what that does is that will take your drug charge and elevate it from where it currently would have been and elevate it to a higher felony drug charge one step above. So let's say you had possession with 1 to 4 grams, right? That would normally be a 3rd-degree felony. But if they add the intent to deliver part, that could elevate it up to a 2nd-degree felony, which would be a higher charge, punishable by up to 20 years in prison and up to a $10,000 fine. Okay, we talked a few minutes ago a little bit about drug paraphernalia. I won't spend a whole lot of time on that because that's a Class C offense. But then you've also got some other things. And when you talk about drugs, Texas drugs, drug charges, it's hard to fully understand them until you understand that there is a drug schedule in Texas. Under Texas law, the severity of the crime is based upon whether or not your particular drug falls within a particular schedule under Texas law. So what do we see under the Texas Controlled Substances Act? There's a complete listing. You have a Schedule 1 drug. Let me give you some examples of this. These are substances that have been deemed to have no medical use and are known to be extremely addictive. Marijuana, well, here's going to give you some examples. Heroin, ecstasy, mushrooms, LSD. You go down the list. Those are some examples of Schedule 1 drugs, okay? What about Schedule 2? Schedule 2 drugs may have some medical use associated with them, but they still carry a high risk of addiction. One of those examples might be methadone, opium, Ritalin, morphine, pure codeine, hydrocodone, OxyContin, Percocet, methamphetamine, certain types of amphetamine and methamphetamine, PCP, certain barbiturates. Those are listed under there. And you can have some prescription drugs that fall under that Schedule 2. Now, Schedule 3 drugs are known to have a medical use, but have also been known to be abused in a recreational capacity in some sort, okay? Let me give you some examples. Ketamine, codeine, Vicodin, Lortab, anabolic steroids. Those are some examples of Schedule 3 drugs. Then you get to Schedule 4. These substances are typically prescribed for medical use, but once again can be used for recreational purposes when people choose to do that, and they believe they're subject to being abused. Here's some examples of Schedule 4. Xanax, Valium, Darvon, Darvocet, all of these are examples of that, okay? And then Schedule 5 drugs are the least dangerous of those controlled substances, but can carry some potential for abuse. Schedule 5 would be cough suppressants with codeine and other types of more like medical treatment type drugs that are listed there, okay? Now let's talk for a few seconds. Those are the scheduled drugs. Those are all listed as, hey, these things are illegal. If you're possessing these, you can end up going to jail and being charged with a very serious crime. How do the police catch people? How do the police end up bringing people into jail and charging them with a drug crime? It's almost always in some type of accidental way as a part of some type of investigation. For instance, it's routine that if you're in a traffic stop, if a police officer smells the odor of marijuana, of burnt marijuana, then the next thing they're going to do is they're going to want to search your vehicle. And they're going to try to claim that that is a basis for them to be able to search your vehicle. And so drug investigations can begin in many ways. In just that type of way, where the officer sees something or smells something, or it can be an undercover drug operation where the narcotics division is using informants and undercover officers looking to try to find ways to determine where drugs are being sold. There's all kinds of things. I mean, you start getting into the federal side of things, you can have stakeouts, you can have wiretapping, you can have informants, where it's fairly common, where even state police will look to try to get a hold of someone, arrest them from a very small drug crime, maybe a first-time offender, and then try to put pressure on them saying, look, if you don't work off your case, we're going to charge you with this and your future, your whole life is over. And they want to try to pressure them to give up 3 people minimum of 3 people that are above them in the food chain on the drug distribution side of things. And then if they don't work those people off, they don't provide those to the police or to that officer, then they're going to charge them anyway. Be careful when you get presented with that sort of situation. If you ever have a narcotics officer, any type of officer, try to make you work off your case, you need to get the help of an experienced drug defense attorney that knows how to deal with the narcotics division in that situation so that you are not abused and that they do not take advantage of you in that situation, okay? So there's informants, there's task forces, there's controlled buys. What about a controlled buy? There you can have an undercover officer coming trying to sell what might appear to be something, where there's a controlled buy that takes place and trying to catch someone in the act of either buying something, and here's the way they usually do it. They'll go and try to pretend like they're going to buy something from someone else, and then in the process of that, they arrest that individual based on that controlled buy, okay? But here's some of the more common examples. What about a search and seizure? You know, under the United States Constitution, under the Fourth Amendment, it protects each and every one of us from an illegal search and seizure without a properly executed warrant. What this means is that the police cannot just search your home or you or even your vehicle sometimes without first providing at least probable cause and obtaining a search warrant. Now, the warrant, if you talk about a search warrant, first of all, it needs to specify the areas, the buildings, or the vehicles that are to be searched. They have to be specific. It can't just be search whatever you want, looking for whatever you want. There has to be specificity. It's important to take a look at what's called the search warrant affidavit. The specifics within that search warrant affidavit will provide you the context of being able to determine whether or not what has been done, what the police are relying upon is legal or not, okay? And you're going to want to go over that with your experienced attorney, your criminal defense attorney, to be able to make sure it's being treated properly, okay? So here's the point. What if you, instead of it being a search warrant situation, what if it's a search of your vehicle? Now here's the thing, the police do not normally have to have a search warrant in order to search your vehicle if they reasonably believe that to have probable cause of drugs being in your vehicle or evidence of some other crime. Here's how it normally happens. You're pulled over, you're stopped for what they believe is some type of traffic violation. They walk up to you, they begin to look at your car, and they think that they see, well, either an odor of marijuana, or maybe they see what they think are drugs in plain view. And here's what they're going to do first. They're going to want you to give them consent. They're going to say, hey man, listen, we're just pulling you over. Do you mind if we take a look in your car? Now I want you to understand, refusing to give consent may not stop them from searching your vehicle, but if you emphatically state to the officers that you do not give them consent to search, what evidence they may find if they choose to search your vehicle may not be able to be used against you in court. So there's an old saying in the law that consent cures all. If you tell the police, yeah, go ahead, search my car, they might not have had any legal reason to search your car, but at that moment, when you say yes, they don't have to wait for anything. They just jump right in, and you've basically given up some of your rights as it relates to that situation, okay? So you have a right to refuse consent. You can say, no, sir, I don't believe I've done anything wrong. I do not give you consent to search my vehicle. That may then prevent them from either searching your car, or it may lead to an illegal search that you may be able to get your case thrown out in the future. Now, a common way for police to search your body is to do what's called a pat-down search. What if a police officer just walks up to you and you're walking down the road and he wants to begin to speak to you? Well, here's the thing. Generally, they can talk to you. They can come up and have what they call a consensual encounter, but searches of your body or clothes that you are wearing are not allowed unless you have either been arrested or you've consented for that officer to search you. So whatever you do, why would you ever consent to the police officer doing a pat-down search of you? Do not ever, as a general rule, don't consent to a police officer searching you and doing a pat-down search, because in doing so, you're waiving some of your rights against an illegal search and seizure, okay? So now if you've been arrested, that's a different story, all right? If you've been arrested, they can actually do a search, a pat-down search, to make sure that you have no weapons for their safety. And if they have probable cause to believe that you are possessing drugs, they also can do a search for areas in which those drugs could be found, all right? Now, I've told you this already, but you have an absolute right to refuse the search. Some people will allow the police to search themselves, their cars, and their homes. And here's why. I hear people say this all the time. I don't want to look like I'm not innocent. I didn't do anything wrong. I mean, I feel weird if I don't say yes. I should say that. Now, look, the police are hoping that you're going to think like this. You may not want to, put it this way. What if there's no drugs that you have, but what if they start searching through things and they find something else that they decide that they want to try to charge you with that's innocent, but it's twisted to make it look like maybe you did something else wrong? It could be a variety of other things that the police might be able to find. The point is, you are giving up your privacy rights in that situation, and you don't have to do so, okay? Now, the steps against you in a criminal case, in a drug case, let me just go over this very quickly. If they arrest you, let's say you're arrested. If you're arrested, you'll be taken to the county jail. You'll be booked in. First thing you'll do is you will be arraigned. Essentially, an arraignment is the opportunity for a judge to tell you what your charges are, and a bond will be set. You do not have to plead guilty. In fact, you should not have to say anything. You have the right to make sure, a Sixth Amendment right to counsel, and you're not going to want to plead to anything. You want to fight your case. Once a bond is set, you or a loved one then can post your bond. You will then be released from jail, and then you will have a series of court dates. These are called pre-trial court settings. At that point, you can hire an experienced criminal defense attorney to dig into your drug case, to be able to get access to your police reports, sit down and take a look at everything. That's going on, formulate a very specific custom defense for your drug case and your specific situation, and then there will be a series of court dates. Depending on what county you're in, that can be as short of a time frame as 2 or 3 months. It can take up to 2 or 3 years, depending on if it's a misdemeanor or a felony crime, okay? And then eventually, if you can't come to a resolution during those negotiation sessions at those pretrial settings, your case will be set for a jury trial. And before your case goes to trial, your attorney can file certain motions. Maybe it turns out that the police did some things that are illegal. If that's the case, your attorney can file a motion to suppress. They can also file a number of other types of pretrial motions to try to put you in the best possible position in order to win your case at trial. These are all things that have to be done leading up to the trial. Then you go to trial. Trial is similar, but not as exciting as what you see on TV. At trial, there is a jury selection where jurors are determined. You try to find jurors that are fair and hopefully favorable for your side. And then you're going to end up having opening statements. There's going to be direct examination of witnesses, including police officers, by the prosecutor. But your defense attorney, has an opportunity to cross-examine those witnesses and expose some of these things that we're talking about if they acted improperly or illegally, or maybe it just can't be proven. Remember, when your case goes to trial, the prosecutor's got to prove that case beyond a reasonable doubt. Failure to prove the case beyond a reasonable doubt will result in a not guilty verdict at a jury trial. So you have a right to a jury trial. It doesn't mean that you have to go to trial, and generally we're talking 90+% of cases do not go to trial. But at the end of the day, you want to know that you're going to walk into that courtroom with an attorney that knows how to try a case if it turns out you need a trial in order to be exonerated from your drug charges, okay? Now, obviously, one of the things we look at next is we've talked a little bit about penalty groups. I could get into it a little bit with you with federal drug charges. That's going to be reserved for a different video, and that's a different video series. But let's talk for a few minutes about drug defenses. So when we look at the possible defenses to drug charges, if, let's say, there's an illegal search or seizure, your attorney could file, as I mentioned a moment ago, a motion to suppress. And at that motion to suppress, it could be that the judge would agree that the police acted illegally. Here's the way this works. If they violated your Fourth Amendment rights to search and seizure, and if they acted illegally, the judge may rule that that evidence is inadmissible. If the evidence after the search is inadmissible, there is no case. Your case is thrown out, okay? So that's one of the areas that needs to really be examined. But let me give you some other possible defenses, and I'll just cover them very quickly. Maybe you were stopped and there was no probable cause, or maybe no reasonable suspicion to stop you. Maybe the officer claimed he pulled you over for a traffic violation, but your defense attorney looks it up and sees there was no traffic violation. In fact, you were following the law. If they pulled you over illegally, your case can be thrown out, okay? Also, what about if there was a pat-down search and there was no reasonable basis to believe that you were carrying a weapon or drugs of any kind? Without that probable cause, these officers cannot act on a mere hunch just because they want to pat you down. That could be a basis for whatever they found on your person to be excluded from a trial, all right? Also, searching a vehicle without your consent and or without a proper search warrant. If you didn't give consent and they didn't have probable cause and they didn't have a warrant, that might be illegal. And then searching your home without consent. What if they come to your door, knocking on your door saying, we'd like to come in and take a look around, but they don't have a search warrant? If you refuse it and they try to do that anyway, that will not be admissible in a court of law when it comes to your jury trial. Here's another one. What if they continue to try to question you after you've already requested for a lawyer? Okay, and we're going to talk about this here in a few minutes, that you can begin to discuss a little bit about Miranda rights, and I'll get into that in a minute. But if they violated your Miranda rights and it turns out you provided information through an interrogation that they try to use against you to link you to these drugs, that violation of your Miranda rights could result in those statements not being admissible, and they may not be able to prove your case. All right, now let's talk about this. What if they cannot prove intent? In order to be convicted of possession of a controlled substance, the prosecutor must prove that you knew or had reason to know that the drugs were in your possession. So if the best example of this is you're a passenger in a car, it's someone else's car, they pull you over, they find drugs under your seat, and you had no idea. There's a very good argument there that you did not know those drugs were there because it wasn't your car and you were just hitching a ride. In that situation, if the prosecutor cannot prove that element, that's a great defense. You had no intent to possess those items. Also, an experienced criminal defense attorney possibly may be able to get your drug charges dismissed if the prosecutor cannot prove that there was an affirmative link between you and where the drugs were found. Here's a good example of that. And so the defense is no affirmative link. That's the defense. For example, if you share a home with several people, maybe you're living in a home with 4 or 5 other folks, or there's a roommate situation, and drugs were found in a common area. What if they're found in the living room area over where maybe where the coffee table area is? That prosecutor must prove some way to affirmatively link you to those drugs. In other words, is your wallet sitting over there by it? Is your purse sitting over there by it? Is there a bill sitting over there by it? Is there with your name on it? They've got to specifically affirmatively link you to those drugs. Otherwise, they're going to have a hard time proving that case. All right. And we've already talked about unlawful searches and seizures. That's another really good defense. And then also, what about a search incident to arrest? So the rules surrounding search and seizure change when you've been placed under lawful arrest. Here's one thing. If the police arrest you for something else and they really only used that arrest as a pretext to search you, you might end up having an unlawful arrest. We've seen instances where they arrest someone for, say, a traffic violation and they put them in the back of the patrol car, right? And then they use that as a reason to go search your car and they find drugs. That could be seen. There's a Supreme Court precedent that establishes that could be an illegal search. That's an important one to look at, all right? What about improper handling of evidence? What if the chain of custody of where the drugs started off and how they got to the lab, what if that is improperly established? If there is a gap or if there's a break in that chain of custody showing how the drugs got to where it needs to be, where they were supposed to go, you could have an argument that the drugs are not admissible. And now, finally, I'm going to spend just a few moments and be done here to talk to you about a violation of Miranda rights. When we talk about violation of Miranda rights, what does that mean? Well, Miranda rights are primarily designed in order to protect you from statements that are given if they do not provide you your rights, but there's certain rules that have to be in place. Number one, you have to be in custody. That means you're not free to leave, okay? So that's number one. And then number two, you must be interrogated. So let me just say this. If a cop walks up to you and starts talking to you and he says, man, you're free to leave, I don't care, you can walk off. And then he starts asking you questions and you respond, that can be used against you, okay? Well, what if he says you're not free to leave and you got to stay right here, but what if in that situation he says, well, you're not free to leave, but then you just start talking. He doesn't ask you any questions. Well, now you are not being interrogated. You're just giving what they call a res gestae statement. You're just spouting it out. You're giving a spontaneous utterance of information that is also going to be able to be used against you. So you have to be in custody and you have to be interrogated. And in that situation, they must read you your Miranda rights and you must affirmatively waive those rights. If they fail to do that, all of your statements may be able to be excluded from court, and that could very much affect your case if there was any statements that you gave that they used against you, okay? Finally, there are some other things that are going on right here, and I encourage you, I've got some other videos on this. You could go look and see that, maybe you had medical marijuana exemption. You may have also had the issue of entrapment that took place. And listen, even if none of these defenses apply to you, I want to encourage you, you need to speak to an experienced attorney in your county in Texas, because there are sometimes diversion programs, particularly for first-time offenders, where your case can be handled in a very beneficial way that could really result in a positive result for you if you look into those items, okay? So here's what I want to say. If you're looking for an experienced drug defense attorney that's handled these issues, particularly if you're in the North Texas area, don't hesitate to contact the Fulgham Law Firm at 817-877-3030. We'd be happy to go over your specific fact scenario, give you a free case analysis, and see what we can do to help you. By the way, I promised you I'd give you a free ebook. All you got to do is click the link below. I'll send you over the ebook, What to Do If You've Been Charged with a Drug Crime in Texas. Thanks again for joining us here today. Look forward to seeing you in our next video series. And subscribe to our channel if you liked what you heard today. We'll see you next time. Thanks again.